Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to our channel. So, some weeks ago, Nigerians were following up on the case between Greenspan and Bola Ahmed Tinubu about his past dealings in United States of America. Of course, there was a final date given, May 2nd, where all the files and the juicy details of what he did in United States many years ago will become public knowledge. Well, as we speak, informations are reaching us. But before we go to the newspaper, kindly subscribe to our channel. Where the Federal Bureau of Investigation and FBI and the Drug Enforcement Administration (DEA) as of Thursday informed the United States District Court that they require an additional 90 days to produce investigative reports related to an alleged drug case involving President Bola Ahmed Tinubu dating back to the 1990s. Now, in a joint status report submitted to the District Court for the District of Columbia, the two federal agencies, alongside the plaintiff, Aaron Greenspan, made the request to extend the timeline. The case concerns Tinubu's alleged involvement in the Chicago ring in the early 1990s. However, Greenspan, an American legal transparency advocate and founder of the platform Plainside, rejected the 90 days extension and instead proposed a 14-day deadline for FBI and DEA to produce the relevant records. The district court, presided over by Judge Burl Howell, had previously ordered that the agencies on April 8, 2025 to search for the process records relating to the Freedom of Information Act (FOIA) request submitted by Greenspan. The original deadline for the agency to submit the report was May 2nd, 2025. Greenspan filed 12 FOIA requests between 2022 and 2023, seeking information about Chicago-based ring in which 4 individuals, including Tinubu, were allegedly involved. Report has that this request also sought documents on other individuals linked to the case: Lee Andrew, Edwards Moores, Adegboyega Akande, and Abiodun Agbile. Previously, both the FBI and DEA had issued global responses, refusing to confirm or deny the existence of the requested records. However, the court ruled that such responses were inappropriate in this case. In the joint status report filed on May 1st, 2025, the FBI and the DEA informed the court that they had begun searching for the non-exempt portions of the requested records. They anticipated completing their search within the next 90 days. Despite this, Greenspan argued that the agencies should produce unredacted versions of the document they had already identified by next week. He also emphasized that the remaining records should be provided within 14 days, accusing the agency of failing to provide a valid rationale for why the document search would take up to 90 days. He signed Greenspan's proposal for a 14 days extension, and 2 lawyers representing the defendants, Edwards Matthews Jr. and Jared Littman. Now, the report reads: Aaron Greenspan, which is the plaintiff, and defendant Federal Bureau of Investigation (FBI) and Drug Enforcement Administration (DEA), the only remaining defendant in this case, respectfully submit the following joint status report, proposing a schedule to govern further proceedings pursuant to the court order of April 8, 2025, ECF number 47. Pursuant to the court order, the defendant FBI and DEA must search for and produce non-exempt records responsive to the plaintiff's FOIA request, FBI request number 1588244-000 and 1593615/000, and DEA request numbers 22/00892/F and 24/00201/F. And the FBI and the DEA have initiated their searches for response, non-exempt responsibly reasonably segregable portions of records requested by the plaintiff and anticipate completing their searches in 90 days. Now, given the years-long delay already caused by the defendant and the fact that many responsive documents have already been identified, the plaintiff proposes that the FBI and the DEA complete their searches and production by next week, or at the very least produce unredacted versions of the already identified document by next week, with the remainder completed in 14 days. The defendant provides no rationale for why their search for documents should take 90 days. The plaintiff intends to request reimbursement for its cost, the filing fee of $402 and $38 for certified mail postage totaling $440. The defendant proposed that the parties submit a joint status report on or before July 31st, 2025, to update the court on the case status following the agency's search for response, non-exempt, reasonably segregable records requested by the plaintiff. The plaintiff proposes that they submit a joint status report on or before May 31st, 2025. Okay, in summary, what they're saying is the agencies are insisting that it should be 90 days. They want to do this and that the search will take a while. But Greenspan is saying, oh, bros, please, what do you put me? You guys have been on this search for years now, for months now. We have been going back and forth. Why there's no rationale giving us 90 days. There have been this undated report that the raw copies somewhere. Bring out that raw copies somehow. Then 14 days you can use it to do your normal whatever, but we need it out. And some few days ago, it has been a case of the likes of Sonwolu and the likes of Ojuzokal is screaming and shouting that Peter Obi has been selling in the country, painting the image of the country black out there, that each time he keeps talking about Nigeria, that he is not good, that he's not being patriotic. But other Nigerians believe that the leadership of Nigeria itself is the one painting Nigeria black image, giving them a wrong image out there, that this issue of a democratically elected governor being suspended by another democratically elected president and giving a state of emergency where there is no issue clearly shows that we have issues with our leadership. And coupled with all these records, a lot of things are really not jiving. But the question now is, Nigerians have been waiting, honestly, what they want to see these records. 2nd of May is here, and now we are hearing it's going to be 14 days, although the court has agreed to the 14 days. And I know that come that 14 days, something else again will happen. But we are hopeful, because the United States is definitely not like Nigeria. In fact, we have not seen it this fashion in Nigeria. Look at how they are pursuing things, and citizens can file a case and they get their response. We can't do that in Nigeria yet. There should be, if government filed a case, or like Fubara filed a case of defection, and the Supreme Court said there was not, so there's no evidence to show that Martin Emewele them defected. With all the video evidence everywhere, what can we say? There are very major cases being turned to joke, much more a major case like this. Well, let's see how it plays out. Now we know that as of today, no such file will be coming out. Let's go wrap it up. Let's meet up now.